Hi Lady Posse. So if you don't know me, my name is Michelle Whitehead and I'm a lawyer. I provide business serenity through wise management and legal support. A question was asked, a really important question, which was what happens if you fail to make a will, if you die without one? Now the short answer to that question is that things get pretty complicated. Someone who hasn't made a will is intestate, so your estate has to be administered as an intestate estate rather than dealt with by your executor under probate. So that's the technical language for it all. So what does that mean in real life? First, if you've left a will, all the person that you've named as your executor has to do to start with is to make an application for probate, and that's relatively simple and can even be done by the person themselves, or a lawyer can do it really quickly. If you die intestate, the first thing that happens is the Supreme Court has to appoint someone to administer your estate, so they have to appoint an administrator, and that may not be the person who you would have chosen. The administrator's duty is to work out what all your debts are, work out what all your assets are, work out who your dependents are and who the people are who are entitled to expect you to have provided for them in your will. Another difficulty that can arise is if your next of kin is a child, a minor, or is intellectually disabled or unable to act for themselves in their own right, because in that case the administrator is under a very special, much more extreme duty to manage the estate for the benefit of that person, and they may actually be required to pay what's called an administrator's bond, where they have to come up with enough money equal to the account which is paid into the court and held, so that if they mismanage the estate in any way, that they can pay back the debt that is then owing to the person who needs protecting and needs care, that child or that intellectually disabled person. And so that's something that doesn't happen if you've got a will. If you've got a will, then it's just there's still that same level of duty, but you don't have to pay that bond into court because you've been named as the executor, so you've got the deceased person's trust in you is already proven. Whereas in the case of an administrator named by the court, they don't have that direct evidence that the deceased person would have trusted the administrator, in the same way that you're naming someone as your executor shows that this is the person you trust to manage your estate. And they have the same sort of duties on them, like so they can be sued if they haven't done their job properly. But there is that base level of trust there to start the process, which makes it so much easier for them to get started. Then there's the question of who gets what. So if you've made a will, you've put out really clearly who your dependents are, who are the people who are entitled to rely on you to provide for them, and how you want things distributed, who you want to make special gifts to, what percentages you want the rest of your estate, the bulk of your estate, to be distributed in. If you die intestate, all of this is managed under legislation. So what happens if you die intestate in the real world? What does this mean? And this is where it gets hugely, hugely complicated. So the first thing is to define some terms. So there's spouse, and spouse in this context means a married person, so your husband, or a domestic partner. And a domestic partner is a de facto spouse, and a domestic partner requires that you have lived with them for more than 2 years, or you have had children with them, and a domestic partner can be of either gender. So both of those are classified as spouses in this scenario, in this discussion. So get things quite clear. Spouse, someone you're married to, or someone you've lived with for more than 2 years, or someone you've had a child with. So what happens if you die intestate in the real world? What does this mean? And this is where it gets hugely, hugely complicated. So the first thing is to define some terms. So there's spouse, and spouse in this context means a married person, so your husband, or a domestic partner. And a domestic partner is a de facto spouse, and a domestic partner requires that you have lived with them for more than 2 years, or you have had children with them, and a domestic partner can be of either gender. So both of those are classified as spouses in this scenario, in this discussion. So get things clear. Spouse, someone you're married to, or someone you've lived with for more than 2 years, or someone you've had a child with. Now, multiple spouses means any combination of married person and or domestic partner or partners of the same and or opposite sex. And it is quite possible for you to have more than one spouse, multiple spouses in this sense. The next term to define is issue. Now, issue is your lineal descendants, such as your children, grandchildren, and great-grandchildren. So the first line is your children, but if your children are deceased and they have left children, then your grandchildren will step up into your children's place, and the same with great-grandchildren. And if you thought that was complicated, here is where it gets real fun. This is what happens if you die without a will and you have a blended family, or things get complicated. So let's start with the really simple stuff. If you have a spouse and no children, so if you just have one hubby, then he gets the lot, everything that you own. That means nothing goes to your parents, nothing goes to your brothers and sisters, nothing goes to your best friend, nothing goes to that charity you always intended to support. It all goes straight to him. If you have multiple spouses and no children, then the money will be split equally between them. Everything you own will be split equally between them, and they will have to agree on how it's all divided, and you can imagine how messy that would get. And the same thing if those spouses have children. So even if you have had a really close relationship, say with your stepdaughter, and you wanted your estate, a large percentage of your estate to go to her education, the estate would be split between maybe her father and the other person with whom you'd been in a domestic relationship. It just gets split between the spouses at that level. So if you have multiple spouses and you have children with those multiple spouses, so maybe you've got 2 children with one father and another child with a different father, then the estate still gets split between the fathers. It doesn't get split between the children at that level. So that's another complication. And then, so what if you have your spouse, so say your current de facto partner, and you have children with your ex-husband, so children of an ex-spouse or ex-domestic partner. In this case, the estate will be divided between the spouses and the children. So, and this is the same. For example, if you have a husband and you have 3 children with your current husband, and you have an ex-husband and you have 1 child with him, the estate will get divided like this. One spouse or the spouses share between them a legacy of $350,000. So the first $350,000 worth of your estate gets shared between the spouses equally, regardless of the fact that there are more children from one relationship than the other. They get equal share. And also your personal effects, so all your personal belongings get split up between the spouses, between the current husband and the ex-husband. split, then 1/2 of the remainder of your estate, so anything over 350,000, gets split in half, and half of that gets shared between the spouses. Then the remainder gets spread equally between the children. So the children basically receive 1/2 of your estate minus $350,000. If you have less than $350,000 in your estate, the children get nothing. It all goes to the fathers, and they're expected to provide for the children. So if you have adult children, you can imagine what that would mean for them. Particularly if they, say for example, you had an adult child. I've seen a situation where there were a long-running marriage, a marriage of 40 years that had 3 adult children. Then the father went and married again, or got into a relationship again with a new lady, and those adult children were so determined to, previously they'd had a good relationship with the stepmother, but once the father died and without a will, and the intestacy laws kicked in, the family tore apart. And that's one of the main reasons to have a will, because intestacy laws tend to tear families apart because they're not tailored to the reality of a particular family. They are a generic box, and you don't really want your family pigeonholed into a boxes at a time when they're grieving. You want them to have the security and serenity of knowing that they're abiding by your wishes. And that's what the main difference between having a will and not having a will is, that you're taking away that doubt and confusion and fear and worry and sadness from your family by letting them know exactly what it is that you want. So they don't have to try and guess. They don't have to worry that they're getting it wrong. They don't have to try and work out what it is that you might have wanted, and then see that whatever they think that you might have wanted, see that trashed because it doesn't fit in with the intestacy laws. Okay? That's the big difference. And that's why I say everyone needs a will.